Hi, I'm Kirk Evans, president of U.S. LawShield, and we're here today to talk about a recent decision out of the Federal District Court for the Eastern District of Virginia. So on May 10th, 2023, Judge Robert Payne in the Federal District Court for the Eastern District of Virginia issued a ruling striking down the federal prohibition on an FFL selling a handgun to an individual between 18 and 20 years old. So what the judge ruled was he followed the Bruen decision from New York last year, did a two-step analysis. So one, does the ban on selling handguns to individuals 18 to 20 infringe on their Second Amendment rights? He ruled that it did. And then he went back and said, are there any historical analogs from the time of the Constitution that are comparable requirements or restrictions that we could follow here and say that that's what the founders were thinking about when they passed the Second Amendment? He ruled that at that time there were no general age restrictions on folks between 18 and 20 that would prohibit them from owning firearms, and said there's no historical analog. The law here in question is unconstitutional. So what does it mean for today? So for today, as we sit here at the time of this video, which is May 15th, 2023, there has not been what they call a final judgment entered in the case. They are looking at whether this can be certified as a class action, how the final ruling will apply. And so there's been no final judgment, just the court's opinion. So what does that mean? Right now, if you are an individual 18 to 20 and walk into a gun store, you probably still are not going to be able to purchase a firearm from that FFL. At this point, if you're an FFL and wish to sell a firearm to folks 18 to 20, it's probably advisable that you wait until a final order is entered. And then, even then, it's probably going to be stayed, that final order, until this can reach a court of appeals. So there's been a couple other rulings in other states, similar, but not exactly the same as this ruling. So in Texas and Minnesota, federal district courts have ruled that their permitting schemes are unconstitutional because they prohibit 18 to 20-year-olds from getting licenses to carry. Different than what happened in Virginia. In Virginia, they struck down the federal law that prohibited the FFL from selling to those 18 to 20. So what does this not mean for folks in Virginia? So in Virginia, if you're 18 to 20, you probably still aren't going to be able to purchase a firearm until there's a final order and all the appeals are exhausted. In addition, this law is only on the purchase of firearms by 18 to 20-year-olds. It does not have anything to do at this point with Virginia's concealed carry permit licensing scheme. And so this ruling itself right now does not address whether 18 to 20-year-olds can go out and get a concealed carry permit in Virginia. So let's wait and see what happens. It might be analogous. We might see further decisions, other courts ruling on concealed carry permits for those 18 to 20 in Virginia, but this case does not involve that issue right now. So stay tuned for future developments. Certain to be other cases, appeals, further rulings. We'll keep you posted. Thank you.